Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I am Ross Simon from Maserumule, Corporate Employment Law, and in today's episode we will be unpacking an important issue. What if a workplace incident caused an employee's illness or injury? What is expected from the employer before services may be terminated? Today, we're diving into a significant labor law case of Le Franschhoek Hotel versus CCMA and others that sheds light on this issue. This case explores the legal responsibilities employers must uphold before dismissing an employee due to incapacity resulting from a workplace incident. Stay tuned as we break down the facts, the CCMA's ruling, the grounds of review, the Labour Court's decision, and the key takeaways. Let's start with the facts. The employee, an executive chef at Le Franschhoek, was off duty in 2019 when he received an urgent call. The kitchen was on fire. With prior firefighting training, the employee rushed to the scene, took charge, and together with his team successfully contained the fire before emergency services arrived. While they saved the building, the employee inhaled a significant amount of smoke, which later took a toll on his health. Months later, the employee began experiencing sleep disturbances, panic attacks, and anxiety, leading to a diagnosis of major depressive disorder with severe anxiety. Initially, the employer granted him 2 months off for treatment. Thereafter, they initiated an incapacity hearing, which resulted in the employee's employment being terminated. But was this dismissal fair? Let's find out. The employee challenged his dismissal at the CCMA, arguing that his condition was directly linked to the workplace incident. The Commissioner found that the employee's illness was indeed caused by the workplace incident. An occupational therapist confirmed that the employee could return to work with reasonable support. The employee himself was willing and eager to resume his role. However, his employer refused to make accommodations to facilitate his return. Applying the Code of Good Practice on Dismissal, Item 10, Subsection 4, which governs incapacity due to workplace injury or illness, the Commissioner ruled that the employer had a heightened duty to accommodate the employee before considering dismissal. Since reasonable accommodations were possible, his dismissal was deemed substantively unfair and he was awarded compensation. Disenchanted by the CCMA's award, the employer took the matter on review to the Labour Court, arguing that the decision of the Commissioner was one a reasonable decision maker could not reach. However, the court upheld the CCMA's ruling, highlighting that the employee's prolonged recovery was largely due to the employer's lack of support, which in the circumstances placed a more onerous duty on it, considering the genesis of the injury sustained by the employee. By the time of the incapacity hearing, medical experts had already confirmed his readiness to return. At the end of the year, the employer had not filled the employee's position, proving that the role was still vacant. The employer's failure or refusal to permit the employee to assume his position constituted a dismissal. Accordingly, the employer's review was dismissed. This case serves as an important lesson for employers dealing with workplace injuries and illness. Here are the critical points. Workplace injuries or illness require special consideration. If an injury or illness occurs on the job, the employer has a greater duty to assist the employee before resorting to termination. Accommodation is crucial. If an employee can return to work with reasonable support, the employer must provide that support rather than terminating the employee outright. Follow the Code of Good Practice dismissal, specifically Item 10, which outlines the employer's responsibility when dealing with incapacity due to workplace injury or illness. A failure to accommodate can lead to unfair dismissal. If an employer refuses reasonable adjustments for an injured or ill employee, termination may be successfully challenged. Colleagues, this case underscores why employers must handle workplace injuries and illness with care. If they fail to offer reasonable support, they may face the consequences of an unfair dismissal. That brings us to an end of this week's episode. Thank you for joining us. We hope you have found our discussion informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me at ross@massconsulting.co.za. Until next time, bye-bye.